All right. So the Fifth Amendment centers around what happened before Mr. Denault got sentenced to solitary confinement, what led up to that sentence. So what happened is after the police found that the lady who he had murdered, they found her body, they asked witnesses, they went to his house because they heard that he was a suspect in this crime. They asked him to come with him in connection with the murder of Andrew Somerville. So he agreed to go with them. He then went into the police facility and they said, we're going to ask you some questions. You're not under arrest. You're free to leave or stop talking if you want to. He said, I want to help you find the killer. So they asked him some questions. Have you ever been in Sleep Suites Motel 417? That's where she was killed. He said, no. Basically, they asked him, like, what were you doing the night in question? He basically like lied his way around saying, I didn't do it. I'll help you find the killer. Now, at the end, they say, we're done asking you questions. He says, okay. They say, we want to do a test. It's a procedural test. Will you go with us? Now, he doesn't answer the question, but he walks with them out of the police facility into a building far away where he is handed off by the police to two technicians who are going to perform a test on him. The test is called the FBME, the Functional Brain Mapping Exam. What the FBME does is it's a fictional technology, obviously, that says they show the suspect an image, and if the suspect has memory or familiarity with that image, the brain flashes. So they sat Denault down for this. The facts of the record say, quote, they explained the FBME to him. They explained that it was purely procedural, much like drawing blood or taking fingerprints, end quote. That's an arguable line, as we'll talk about in a second, but that's what they say to him. He sits down for the FBME test, and then they show him a picture of Sleep Suites Motel number 417. Since he has memory and familiarity with it, flash goes the brain, they take that evidence, they use it against him in court, and they incriminate him. He gets he gets sentenced, he gets convicted. Now, the Fifth Amendment is an amendment that protects against self-incrimination, as in the government cannot compel a person to testify against himself. That's because back in the old days, like a long time ago, the government was concerned about forcibly extracting testimony from the accused. They believe that in our system of justice, the state should have to muster its own independent efforts and its own independent evidence to convict somebody, not simply put a gun to their head and say, if you don't answer, you'll die. So that's what the point of the Fifth Amendment. Now, there are three things that are required under the Fifth Amendment, but one of them is already proven, as you've probably heard if you've judged this case before. The Fifth Amendment says evidence is barred. Evidence is unconstitutional if it's compelled, testimonial, and incriminating. So if the police compelled it from them, that evidence was testimonial and it incriminated them. We obviously know the FBME incriminated Denault, so that's not under contention. So fortunately, just like with the Eighth Amendment, with cruel and unusual, we only have to answer two questions. Is the FBME compelled and is it testimonial? So the first question is was the FBME compelled on Mr. Denault? Now notice in a lot of the facts that I provided you with, I touched on a couple of key things that people will like to point out. When they first brought him to the interrogation room, they asked Mr. Denault, they told Mr. Denault, you're not under arrest, you're free to leave or stop talking. He decided he wanted to continue to talk. Then they said, we're done asking you questions. And they said, come with us to another facility. Now, there's no clear definition of compelled in our fact set. Unfortunately, none of the cases that we've been provided with give a clear definition of compelled. There's one case that says, if your freedom of movement is being restrained, you're compelled. And that's obviously true. If the police like handcuffed you, then you're compelled in that sense to like walk with them. Like if they throw you in a van, then yes, you're compelled. But that's not the only definition of compelled. Obviously, in this case, Mr. Denault was not restrained in his freedom of movement. He could walk wherever he wanted. He was never handcuffed. So the other evidence that people point to instead of just saying his freedom of movement is Miranda rights. Now, if you're familiar, I'm sure you're all familiar, probably more than I am, about like TV shows and movies in which the police or lawyers will say to the suspect, you have the right to remain silent. Anything you say can and will be used against you in court. Now, Miranda was implemented because there were they recognized that suspects who don't have any legal training often feel naturally, inherently compelled to speak. Like if they don't know they have the right to remain silent, they're just going to start talking. And that's not fair to them because they should know that they have the right to remain silent. So the court in Miranda versus Arizona said, before you extract testimonial evidence from somebody, if the person is in custody, you need to tell them that they have the right to remain silent and anything they say can and will be used against them. Now, clearly, in this case, the person was not Mirandized. Mr. Denolf was not Mirandized. He never got told that he had the right to remain silent or leave and that anything he said could be used against him. So the argument goes, were the police required to read him his Miranda? Because if there are circumstances in which the police are not required to read your Miranda rights. If they pull you over after you've been speeding and they say, sir, did you know how fast you were going? They don't have to say your Miranda rights before you answer because you're not in custody and because they're not extracting any information that they're going to use against you in court. It's just an offhand question. So the debate here, what the attorneys are arguing over is, were the police required to give him his Miranda rights? Were they required to tell him that he could be silent? Now, a lot of it hangs on custody because Miranda says when they're in custody, you definitely need to read them their Miranda rights. Because obviously, if they're in your care, they're going to feel compelled, they're going to feel pressure to answer your questions if they're in your custody. Now, there isn't anything in our record that speaks about non-custody. Everything talks about custody. Now, that's not dispositive. The issue is that that's not dispositive. Like, it may be true that if you're in custody, you have to get your Miranda rights read to you. But what about if you're not in custody? It never says if you're not in custody, you don't need your Miranda rights. So the question is kind of open to interpretation, whether or not you need to be in custody. So listen for that argument with the students. Is he in custody? Is he not in custody? What is the definition of custody? That's a great question to ask them. What is your definition of custody? And use their definition of custody. So if they say where his freedom of movement is being restrained, well, he was never handcuffed, so you're saying he wasn't in custody. Okay. Again, I'll be open for questions in just a second. Let's touch on testimonial first. Testimonial is the second element of the Fifth Amendment. The reason why testimonial is an element is because the court has always said we can use the body as evidence, we just can't use the mind as evidence. The reason for that is because let's say that like you wanted to see if okay, so the basic premise is they want to protect the sanctity of the mind because the human mind and the human spirit is what is most precious and shouldn't be intruded on. But if it's just the human body, that's okay. So otherwise, like the person could claim a Fifth Amendment right to not have the jury look at them, because that would be like, it could possibly incriminate them if the jury looked at them. Like that just doesn't make sense. Your physical presence isn't enough for you to claim Fifth Amendment protections. So some particular examples of this, if the police draw your blood, they're looking for the blood alcohol content in your veins. That's not forcing you to, that's not intruding on your mind, that's intruding on your body, and that's okay. Same thing with this. Like if the police take your clothes and they smell smoke on your clothes, that's technically like incriminating, but that's not violating your mind. And again, they're concerned with violations of the mind. So they're not going to consider it a violation of the mind if they smell your clothes with smoke on it. Now, with the FBME, it seems fairly clear that the test is forcing Mr. Denolf to disclose the contents of his mind. I think most people would say this testimonial point leans towards petitioner. Petitioner should win this point, ordinarily speaking, because think about the two key words I said. What triggers the FBME flashing? Memory and familiarity. Those two words are both stuff that has to do with the mind. If you have memory of something, that means you had a cognitive capability of recalling something. If you are familiar with something, it's also a cognitive capability. So because it relies on familiarity or memory, that seems to be very obvious evidence that it's disclosing the contents of his mind. So what does the respondent say then? Okay, so the respondent can make up a lot of goofy arguments, I think. One of the arguments they make is, technically, the brain is just physical. Now, yes, we agree that the mind is like precious and we can't intrude on the mind. But if we're just looking at the brain, we're just looking at if the brain is involved or not, if the brain flashes or not. Those flashes, they're not actually testimony because it's not, the flashes don't disclose the contents of his mind. They might even make the argument, well, it's not a mind reading device because it's not like if your brain flashes, we know you are thinking, ooh, I hate this test, or oh, I was totally there and they're going to catch me. It's not quite a mind reading device where it can understand complex sentences. That's what the respondent's going to argue. Of course, the petitioner is going to come back and say, sure, maybe the flashes themselves are just physical, but the reason it flashes is because the suspect has familiarity or memory with it. And those two things are expressly contents of someone's mind. I think respondent should lose on this argument every time. So, I mean, like, it's really hard to prove that if a person, like, you show this person an image, their mind flashes because they've got memory of it, and you're trying to say that that's not invading on their mind. It is invading on their mind because it's forcing them to reveal that they have memories. Oftentimes, the respondent is most going to rely on the compelled argument because they know that they don't have a super strong testimonial argument. And I think they have a pretty strong compelled argument. So fortunately, it is balanced in that sense. Okay, I'm open for questions. Anything that y'all are thinking? Nothing? All right. Oh, yeah.
So how do you, like, my problem is, I've read this case and I'm very heavily biased against Mr. Denolf. I just don't want him to get any of the privileges because of the cruelty that he committed. Like, how do you keep your own bias from this round? Like, is there a way to?
That is so fair. There are a couple of things that I would caution. Obviously, like, since you're aware of your own bias, that is enough of a natural deterrent to you voting in a certain way because of your bias. I'd also think about the fact that the criminal justice system doesn't say anything goes as long as it's proportional. So, for example, if a person murders 50 people, the government could slowly chop off his finger and chop off his arm with a knife and keep hacking at him while he screams and cries until he bleeds out. And that would technically be proportional to his crime because he killed 50 people. In fact, that's just one life, and he caused 50 people to suffer and their families. But the court doesn't say just because it's proportional means it's okay. They still have limits on what is cruel. So I would just remember you're in a court of law. You're a dispassionate author of justice. We oftentimes think about the Statue of Liberty and how the Statue of Liberty is blindfolded because Lady Justice is blindfolded because, not the Statue of Liberty, sorry, Lady Justice with the scales of balance, Lady Justice is blindfolded because justice is blind. It doesn't use the heart to make its decisions. It simply is whatever the law dictates. And in this case, we just have to consider if it's cruel and unusual.
Ethan, if I'm understanding this properly, the scoring is done on a points basis. So the person, are we saying who wins the court? Like, we're not saying a court decision, right? We're saying basically a scoring of how well the case was argued within those 5 categories.
Yeah, that's right. You're not adjudicating which side won on the arguments, because sometimes the arguments get muddled because of other judges' questions, etc. It's just who delivered their material within those 5 categories the best.
Okay, that's helpful. Thank you.
Yep.
This is very helpful. You are a wealth of information. Oh my goodness.
Oh, good. Thank you.
Time with this, yeah.
I'm glad. Mrs. Wong.
Very helpful. So in the block where it says reason for decision, what do they want?
A fair question, because there's not really a reason for decision, unlike in debate. I just put reason for decision. I just put general comments, and then I say check my speaker comments to see why you failed in particular categories. So when I'm filling out the ballot, I spend more time on my speaker comments than I do in my reason for decision. So in my speaker comments, I'll say, you got a 5 on organization because you were so haphazard and jumped between point and point and spent only 30 seconds on your last point. Or you got a 10 on delivery because you did not stutter at all and you were slow and methodical and believable and real. That's what I do in my speaker comments, and that's where I put most of my RFD. So in my RFD, I say, check my speaker comments for why you got the points that you got. And then some general feedback like, y'all were talking too fast, or good round, everybody, like general comments like that.
I have a question about the last speaker. I mean, the last speaker gets to talk about like all the things that make their position best, and that the last speaker has an advantage because he's quoting what I've said, he's quoting what the opponents have said and partner has said and all that, and I'm going, how do you rate that person? Because that person has an advantage. Like, what is the purpose of that last person and last speech? But
Sure.
why is that person so privileged?
Fair enough. That happens in real Supreme Court oral argumentation, that the first speaker gets a rebuttal, just because in real life, oral argument goes about 30 minutes for the first speaker and then 30 minutes for the second speaker. So by the time the second speaker is done, you've probably forgotten what happened in the first speech. The same is true in a more minor sense of this case of moot court, that you'll probably forget a decent amount of what petitioner said. I don't actually think all rebuttals are super great, because a lot of rebuttals just repeat exactly what you said in the first speech. But that doesn't necessarily persuade me, because now I've heard the other side. So sometimes I want more nuanced responses than just, I'm going to repeat what I said in the first speech. So that's what I would say, like when you're looking out for what to be picky for in the rebuttal. Are they actually giving you anything substantively new? Are they actually grappling with what the other side has said? Or are they just repeating the exact same arguments you heard at the beginning? In which case, it's fine. It's not bad. It's just not excellent.
Is there a good way of, an easy way of keeping track of all the precedent cases? You know, how they start throwing all the precedent cases, like Schmerber v. California, Greg v. Georgia, and sometimes I feel like I can't keep track of them. You know, I don't know what those are. Like, is there a way to just kind of, keep track, like prepare ourselves to to hearing and confronting those cases and not getting confused in the round before the round, without without spending 50 hours in research.
Yeah, that's the difficult thing, is because to be a good judge, you have to be more knowledgeable than the competitors, but the competitors are the ones that are doing 50 hours of research and not you. So that's like a conundrum that is not easy to solve as a parent or as a casual judge. I would say, like, don't worry about the case law too much. You should listen critically to what the case law is saying, and feel free to pick up on things that the case law doesn't say. So for example, I pointed out the custody thing. Sometimes people will say, well, this court case said, when you're in custody, you need to get Miranda. Therefore, the only time they need to get Mirandized is when they're in custody. But that's not what the court case actually said. It just said when you're in custody, you need Miranda. It didn't say when you're in custody is the only time you need Miranda. So just be listening closely to the quotes, but that's about it. I mean, the only other helpful tip I'd give, because I also am not encouraging you to do outside research, I think that would probably be a waste of y'all's time, is check to make sure when you look at the appendix at the very back of the packet, you'll see that about half of the cases are Supreme Court, and then about half of them are not Supreme Court. I can send you a quick list. I can send an email with a quick list of what's Supreme Court and not. Be wary of people who are using lower court cases to sound like Supreme Court cases. That's my only caution. That's the easiest thing. I've heard quite a bit of it. Like, people will say, as this court held in Novak v. Beto. It's not this court. Novak was a court, I think it was like Third Circuit, something that happened in Texas that was not a Supreme Court case. So watching that is going to be a big thing to look out for. But I would not encourage you to like read through all the cases, because that's impossible.
So are they real cases? So some of it is made up, but some of it is real, right? So the cases are real, right?
What was the last thing you said? What's real?
So the cases are real, right? Like what I'm saying is like some of it is made up, like FBME, Mrs. Denal, but the cases are the actual cases, right?
Yes, the cases actually exist in real life. Yes, they all really happen. All the cases. Yeah. Yeah. Okay. I will let you all go then. And thank you for being here. A couple things. Last pro tips, really fast. One is a nice pro tip is to ask competitors the arguments from the other side. So after petitioner is finished, when you write down some of their arguments, ask the respondents to respond to what happened on the petitioner, because sometimes they'll just be two ships passing in the night. You can say to respondent, could you respond to the argument that they don't need to be in custody for them to get Mirandized? That's what petitioner was arguing. What do you have to say to that? That's a great way so that you can hear the back and forth, so you can compare their arguments too. And then in the rebuttal, do the same thing. Could you respond to how the respondent characterized the Fifth Amendment? Do you agree with that characterization? Like that kind of thing can help you adjudicate also fairly well. And then the last thing that I'll say, this is a very specific point, but when you're judging, I think every judge should be asking the respondent on the Eighth Amendment if they think Mr. Denolf is going to experience psychological harm. Because, after 30 years, when you're by yourself in a cell that doesn't even have windows, and the cell is like the size of a parking space, and you have nothing to do except think your own thoughts, it's probably likely that you're going to get psychological damage. I just want to know what respondents are thinking on this issue. It's a hard question to answer, so I think it's a good, sharp question to get them off at the outset. What do you think about the fact that Mr. Denolf, do you think that he'll probably experience psychological deterioration by the end of his stay? What do you think? That was a very specific point, but that's a question I think judges should be asking more often. All right, everybody. Thanks again. Have a good rest of your Friday night. I am sure that y'all have busy Friday nights, so thanks for taking some time to hear me speak. But
Thank you, Ethan.
Well, thank you so much, Ethan. It's super helpful.
good.
Thank you so much for taking your time to educate us.
Yeah, no problem. Happy to do it. See everybody later.
Thanks so much.
Yep,
Thank you.
no problem. You're welcome.